you just don't know how vicious that was. You caught, and I don't normally miss too much, but I missed it. Them motherfuckers admitted, and they know that the speedy trial was denied.
Yeah.
So they knew another record existed.
Yeah.
So why you didn't ask for it? They looked at my case. They seen that the denial was not part of the record. Where is the order from the judge denying?
It say Georgia law. Georgia law, it don't allow you to deny no damn speedy trial.
The minute the motherfuckers realized that there was a speedy trial, he just acknowledged another record. That's what he acknowledged, just like you said. 55430 is another record in itself. Where is the 55430 record? Because you definitely never looked at it. You can never say you looked at it, Georgia Court of Appeal. Think about it. How can they mention a denial when they never seen the record? Think about that now. Georgia Court of Appeal sat there and mentioned a denial, that it was denied. How do you know? Oh, because they said so. No. You don't supposed to go by what they said. You're supposed to look at the record. Do the record say it? If you ain't got the record to say it, then guess what, Georgia Court of Appeal? Your ruling is in error. You didn't do what appellate court's supposed to do. Appellate court's supposed to look at the record. How can you look at the record when the record wasn't even in front of you?
Yeah.
How can you even speak of see, that shit, what you just brought up is vital, boy. That shit there is game-changing, killer instinct shit. Because you just admit that you never looked at the record. How can you look at the record when the record wasn't in front of you? You said it was denied. So if it was denied, what was denied? Oh, it's statutory speedy trial. Okay, under what indictment? Oh, was it on 56-788? Well, I'm looking at 56-7. I don't see no denial on 56-788. What's the next logical thing to do? From any aspect. You say, okay, well, show me the indictment that shows the denial. I need to see the order showing the denial. Because it might be some in that order that favors the defendant or favors the state. But I need to see it. How can you rule on something and you never even seen the denial?
The appellate court are bound by the record transmitted. OCG.
Yes, indeed.
OCG subsection 5-6-41. They cannot rely on assumptions. They cannot rely on characterization. They cannot rely on documents not in the record.
This
This is not a technicality. Georgia appellate law is clear. Appellate court may not consider facts that are not part of the record. If the denial order, if the denial order was never transmitted, was never certified, was never docketed in the appellate record, then the Court of Appeal cannot treat it as established fact. This is not semantics. This is about jurisdiction and due process.